for a century. As I said, we'll see.
We are not looking for a mechanism because Hakim says
Yes.
you can't do it.
Yes.
We are considering whether it is correct.
Correct. I'll take my laws
process. We are faced with all these submissions.
Yes, but I'm not saying when I say my laws are being asked to do it. My laws are being asked to read into the power of setting aside a power of modification or variation. As I said, please look at the CPC, Code of Civil Procedure. Order 41. My Lord knows it. We've seen it several times. My Lord has also seen section 5 and 34 several times. Sometimes, please see Order 41, Rule 32. And this is 1908. So this is something over 100 years ago that the legislature knew. 4132.
Yes.
The judgment may be for confirming, varying, or reversing the decree from which the appeal is preferred. There are three propositions, there are three separate things that have been given. You can confirm, you can reverse, or you can vary. These are all distinct powers which have specifically been given by statute. This has always been the understanding. Look, the problem is if the power of modification is to be read into the power of setting aside, then my lord will see all the other rules that are required to effectuate that also. See, for instance, Order 24, Order 41, Rule 24. When the evidence on record is sufficient, appellate court may determine the case finally. Because appellate court is given all the powers to vary, modify, and decide. That is, none of that is given in section 34. Where are we reading all this into? Entire elaborate scheme which is given in the CPC of Order 41, Rule 22 onwards to 32. None of this is present. How will the procedure work? And why should such a procedure work? Well, that is my point on the larger, but I'll come to my note. The note has been handed over. This is roughly some substance of it. So we have to look for the conceptual basis through which any power of modification is to be found. It has to have a basis in law. Its first can be done through the process of adding words to a statute, which was the argument of Mr. Datar. He'd specifically given a sheet saying, please add the words or partially set aside, comma, modify. That was given to my lords. That has been a specific argument of the other side, not something that is, the problem is this, sometimes this is lost in the flourish of argument. I'll also read this. The petitioners have argued that the power to modify an award. However, there's an absence of conceptual clarity as to where this power is located. Some of the petitioners argue that the statute be amended and certain words added allegedly to make the statute workable. And we say that this argument of Mr. Datar to add words to a statute cannot be made to make it workable is wrong for several reasons. First, the general law of the land is my lords will not add words to a statute. That's the general principle. First principle, because I thought that is rather obvious, but it is important still, to put it out to my lords, that my lords do not add words to a statute. But some months ago, we were arguing on the other side saying you add words to certain other statute. It was not added by this court, saying that we don't have the power, only Parliament can do it. But the same thing here, that there is no power in an arbitration act also, and it will be done by the legislature. Source of the goose, source of the gander. So there is no general power to add words to a statute. Second, they say there is power to add words to a statute in certain cases when the statute is unworkable. It is not as though the Arbitration Act of 1996
or to save it from absurdity.
Yes, but how is this absurd or unworkable? It may not be a desirable effect to some people, but for the last 1996 till 2024 or 25, this system has worked fairly well. It is not as though arbitration in India has collapsed and no one is going to arbitration and people are rushing to court for justice, saying that because there is no power to modify, look, there is an absurdity.
But let's be very frank, I think it's almost 10 to 20% matters this issue is arising.
Yes,
at least before this court.
Well, it matters.
But number two, when you say partially set aside an award, that's also modification of the award itself.
No, Willis, that is,
It is,
Well, we-
because you are
we- we-
saying that this part of the award is to be segregated. And that power exists regardless of the power given in the proviso.
well,
We have not restrained it only to the proviso to 34 2B. We have given it a much wider meaning.
Willis, I'll explain as to why a power to partially set aside can very well be implied without doing any violence to the language.
And
For two
it's
reasons.
it's normally, as a principle of interpretation,
Yes, Willis.
you don't interpret a section by reference to another section in another
Cer-
enactment.
certainly.
That's normally not done.
Absolutely not. Well, what I'm saying is sometimes it becomes a bit of a khichdi argument. We take some concepts from different ideas and put in a cocktail shaker and there out it comes. However, we have to have a conceptual clarity as to what the court can do, what the court cannot do, in which instance can the court do what it can do.
It can be argued, if you look at 33, every attempt is made by the legislature to ensure that the award should, because it's one-step adjudication.
Yes,
Be clear. Arbitration is one step until unless they're two-tier arbitration. It's one-step adjudication, which has its drawbacks.
Correct.
One-step adjudication always has its drawbacks, and sometimes people don't like being put into one-step adjudication. But the legislature attempt is to ensure, even if it's a one-step adjudication, there should be corrective measures available to the parties, whether in form of 33, whether in form of 34 court, or in form of proviso to
Well, I would submit that it is no part of the policy of the Act to uphold an award come what may. Or this is not the IBC, and I've made that my note, where the policy of the Act is always save the company, no matter what. The policy of the Arbitration Act is very clear, Millers, and that has been discussed. We can't start importing that this is the policy or that is the policy. It has been judicially determined. Arbitration is an alternative to a very slow process of litigation that commercial parties often do not wish to have. Because there is an economic cost involved even in delay. An expeditious decision, even if sometimes unfair, is possibly more acceptable to business than a correct decision, which will eventually take 50 years. Because parties cater their economic planning in a particular way. They have to plan also. If there is always a constant doubt as to whether an award will be upheld or set aside or modified, or this will happen, well, this will create economic chaos.
That is their argument that suppose if the award is set aside
Yes, Milad.
and it is set back entirely,
Yes.
it will add to further delay because the process will start from zero.
Milad,
If the power is exercised to vary it will curtail the further
that
litigation.
is the whole point. Milad. My lord assumes that it is in the rare occasion that a court will modify the award, and rather than setting aside and sending people back to the arbitration, rather than doing that, we'll just tinker it here. That tinker it here will no longer ever remain. Just tinker it.
irony is even where it was held that you don't have the power to modify, court is declared.
But that's under 142. And the wisdom of this court, Millets, is given constitutionally by the framers of the Constitution under 142. That wisdom that my lords have has not been.
If we go strictly by the principle of 142,
Yes, it is.
if it's contrary to the fundamental principles of law,
Yes.
you can't excise 142 to
Well, it's the idea of
that
Well,
will be
that is subject matter for another decision. Millets, but
No,
I'm
that's
saying-
settled now.
The
That's
SCBA's judgment, my lord knows, we all know the Supreme Court Bar Association, Justice Anand's judgment. That's true. But if at all a power is to be exercised, it can be exercised maybe by this court, partly because it will not be further challenged. That's on a lighter note. But the fact of the matter is, if this power of modification is given rather than settling the matter once and for all by some court saying, all right, rather than referring you back, we will do it. That modification will happen in every instance. It will be a boon for the lawyers. That without doubt is the case. Whether it's so good for the clients, we are not so sure. So the remedy will be.
All that will happen is both parties will appeal under 37.
Yes, Willard. So rather than one part,
setting aside.
there will be another round. First, there will be a round, Willard, on.
Anyway, there is going to be an appeal. So
Willard, there will be first appeal, first on the question of as to whether it is you can modify or not. Secondly, there will be an appeal on whether it's curable or not. Third, once it is held to be curable or not curable, to the extent of being cured. Well, this will blow a hole through the entire arbitration process, which has worked reasonably well for 30 years. Again, coming back to this, there have been instances of problems, I'm sure. But Miller, there have been instances of problems, as I said, with the justice delivery mechanism as exists currently with the law courts. It's not as though every judgment is correct by every court. You have appeals. Sometimes, Miller, and even a final decision is ultimately reviewed over the years later by the court. But that doesn't mean that just because there is a possibility of an error once in a while, we do greater damage without considering the consequences. Because this court does not have the expertise, with the greatest respect, to examine as to what will be the effect or the consequence of allowing modification power to be read in as a policy. The reason I'm making this argument in law is that the argument was made. If I just now go to my note, otherwise I'll be as guilty of having vague arguments rather than specific on. So the first was on adding words to the statute. Can't happen because the general law does not permit. Second, that it is not as though the statute is unworkable or unfair or unjust. It may result in certain injustices, but the statute works. And third, Millards, the general principle of adding words to a statute is well referred, Millards, to a violation of fundamental rights, where a statute is vulnerable by being contrary to some fundamental right. Article 13 says you will strike down that law. So the courts have devised a principle, Millards, ut res magis valeat quam pereat. Rather than striking down the statute, we will read it down, or we will insert words so as to save it from the vice of unconstitutionality. There is no such thing in a commercial statute like the Arbitration Act. No one has argued that because this is violative of a particular article of the Constitution and therefore is bad, therefore to save it from the vice of unconstitutionality, please read the words in. Well, if this principle is to be adopted, that you can start reading words in even without a threat of unconstitutionality, that will be a remarkable advancement or change, at least, in the law. That is not the law. For fundamental rights, you can do it.
What shouldn't interpret the provisions in a practical and pragmatic way to curtail further litigation?
Yes, Milind. That will come to the next point. I'm saying that Mr. Dattar's argument that please add such and such words explicitly made is explicitly incorrect for the following three reasons are given. So when the words cannot be added to the statute, then what? How does the power to come to modify? There are two principles that have been given, Milind. First principle that has been given is that the word setting aside itself means somehow modify. And the second is a theory of implied powers, that the greater power includes the lesser power. That's the two fundamental logical bases. So as regards the first point, as to the setting aside somehow includes the power to modify, there I only have to refer to the learned solicitors Black's Law Dictionary and Oxford English Dictionary. Setting aside means annulment. If there's any doubt in that, my lord will come to Hakim. Hakim has not been cited to some length, even though this is being reviewed. I just ask my lords to turn to Hakim and see how the learned division bench of this court examine this. That would be in volume 1 of our compilation. Page 1. So Justice Dave will, of course, be aware of it because my lord was part of this bench.
Solicitor's compilation also.
It's also in the solicitor's compilation. But
7 volume for all these.
we made our compilation with all our side so that there is no repetition duplication. My lord wishes, we can refer to the solicitor.
Give me the original one. Don't give me this one.
My lord can take the solicitor's volume. I'll give the paragraph numbers. Yes, please. My lord will take the solicitor's and I'll use that. My lord will take the solicitor's compilation, which is, where is this? For the page number in the solicitor's compilation. But do I not have it? I lot have it.
Solicitor's compilation page 12, 11. SCC.
Yes, please. It's a new compilation. Then may I give paragraph numbers so that my lord can then follow it? Let's see, read paragraph 2 as to how the matter came to court. To the matter under the arbitration under the NHAI, the appeals in the present case raise an interesting question of law as to whether the power of a court under Section 34 of the Act to set aside an award of an arbitrator would include the power to modify such an award. A division bench of the Madras High Court has disposed of a large number of appeals filed under Section 37 of the Act, laying down to the matter of law, at least insofar as awards under NHAI, that 34 must be read as to permit modification of an arbitral award made under the National Highways Act. My lord will then come to, my lord will leave the submissions. Mr. Mehta Milad was saying, had made the same submissions as he has before my lords in paragraph 5. But Milad will come to the findings of the case in paragraph 16. Because the court examined the policy of the Act as well. Because much has been said about what the policy of the Act is. But it's all discussed in this. Paragraph 16. What is important to note is that far from Section 34 being in the nature of an appellate provision, it provides only for setting aside on very limited grounds.
You can go ahead.
Grounds.
Yes, please.
Provides on very limited grounds, such grounds being contained in subsections 2 and 3 of the Section 34. Secondly, as a marginal note of Section 34 indicates, recourse to a court against an arbitral award may be made only by an application for, and highlighted, setting aside such award in accordance with Sections 2 and 3. Recourse is defined by P. Ramanatha Iyer's Advanced Law Lexicon as the enforcement or method of enforcing a right. Where the right itself is truncated, enforcement of such truncated right can also be only limited in nature. What is clear from a reading of the said provisions is that, given the limited grounds of challenge under subsection 2 and 3, an application can only be made to set aside an award. This becomes even clearer when we see subsection 4, under which, on receipt of an application under subsection 1 of Section 34, the court may adjourn Section 34 proceedings and give the arbitral tribunal an opportunity to resume arbitral proceedings or take such action as will eliminate grounds for setting aside the arbitral award. Here again, it is important to note that it is the opinion of the arbitral tribunal which counts in order to eliminate the grounds for setting aside the award, which may be indicated by the court in hearing its Section 34 application. So even 34 formulas first starts from the arbitral tribunal. Then para 18 is important as to what setting aside normally means in international law. Redfern and Hunter in international arbitration states that the model law does not permit modification of an award by the reviewing court as follows. The purpose of challenging an award before a national court at the seat of arbitration is to have that court declare all or part of the award null and void. There's no question of modification, Millard. It's null and void, internationally accepted, internationally recognized. If an award is set aside or annulled by the relevant court, it will usually be treated as invalid and accordingly unenforceable, not only by the courts of the seat of arbitration, but also by national courts elsewhere. This is because under both the New York Convention and the model law, a competent court may refuse to grant recognition and enforcement of an award that has been set aside by a court of the seat of arbitration. It is important to note that following complete annulment, the claimant can recommence proceedings because the award simply does not exist.
One minute, please. This was highlighted by the solicitor also.
Yes.
What has happened is, what was pointed out by Mr. Datar was judicial model was really relating to international commercial transport disputes. So when you are interpreting it, where the Indian domestic awards or the Indian domestic arbitration, do not keep those in mind, because we are then going back at point of time. We are then going back at point of time. Yes, we often use the word that the court power of interpretation is reflective of the legislative intent. But that's all. Legislative intent is then gathered by us and not by the legislature. So while doing it, if we apply this principle, we are applying this principle which relates to international. There's a difference between international arbitration, because then the concept of the law applicable to that arbitration proceedings, the substantive law, the law applicable to the arbitration procedure of that country, all these issues come in.
Actually, they've already come in and said another side as to whether the seat and venue of arbitration and domestic arbitration.
No, seat and venue does come in, but only with respect to the court,
Yes,
but not with respect to the law which is applicable.
I'll make a simple answer to that. My lords are saying to me, as Mr. Dattar has argued, is that the ancestral model law and this discussion of international law will have no relevance because that is in the context of international arbitration. Unfortunately or fortunately, Millets, that is not the case, because my lords will read the preamble to our very act. Yes,
It does say that it relies upon the.
Have at some point not to forget what the legislature has done. No matter how much we may wish otherwise, if the legislature has not only consciously adopted the words of a statute of the ancestral model law, we have been take the preamble with me just for a moment. Please read the act. Whereas the United Nations International Trade Law has give due consideration to the said model law, not something else. That said model law, in view of the desirability of uniformity of the law of arbitral procedures and the specific needs of international commercial arbitration practice, and whereas UNCITRAL has adopted the UNCITRAL conciliation rules, and whereas General Assembly of the United Nations has recommended the use of the said rules in cases where a dispute arises in the context of international commercial relations and parties seek an amicable settlement of that dispute by recourse to conciliation, my lord will see then. And whereas the said model law the 85 model law makes significant contribution to the establishment of a unified legal framework for the fair and efficient settlement of disputes arising in international commercial relations, whereas it is expedient to make law respecting arbitration and conciliation by taking into account the aforesaid model law and rules. This last paragraph is as clear as can be. It has been made. Yes.
You read para 3 of the SOR also. Para 3 of the statements and objects.
Yes, please, I'll come to statement. I'll start with paragraph 1 because even that is relevant. The law on arbitration, because all of it has to be read. Of course, judgments. I'm trying to show that this was not some willy-nilly endeavor done in the blind, unaware of what UNCITRAL decided, and we had a different thing in our mind as to what setting aside means. Everyone in 1985 and 1996 was very clear, and Parliament was certainly very clear as to what setting aside means. It has a specific context and a meaning in international law, Millets. It is not just the 1996 Act. Even prior to that, the Foreign Awards Enforcement Act, Millets, the 63, Millets, the 40 Act. All of these had the concept of setting aside. Parliament was aware. It's not a new concept suddenly accidentally filtering in to domestic arbitration to the root of international law. No, that is not the case. Parliament was aware, and therefore my lord will see the statement of objects and reasons. The law on arbitration in India is at present substantially contained in 3 enactments, namely the Arbitration Act 1940, the Arbitration Protocol and Convention Act of 37, this is the Geneva Convention, and the Foreign Awards Recognition and Enforcement Act 61, this is the New York Convention. It is widely felt that the 1940 Act, which contains the General Act of Arbitration, has become outdated. So an attempt to move away from the 40 Act, and instead the power modification is now read in, it will become like the 1940 Act again. So the attempt of the legislature to move away from the 1940 Act is effectively being argued against, which contains the general law of arbitration become outdated. The Law Commission of India, several representative bodies of the Trade and Industry and experts in the field of arbitration have proposed amendments to this act to make it more responsive to contemporary requirements. It is also recognized that our economic reforms may not be fully effective if the law dealing with settlement of both domestic and international commercial disputes, but both remains out of tune with such reforms. The intention is very clear. Like arbitration, conciliation is also getting increasing worldwide recognition as an instrument for settlement dispute. Therefore, there is however no general law. I'll read the whole thing. I'll read 3 as well. The Conceptual adopted in 1985 the model law on international commercial arbitration. The General Assembly of the United Nations has recommended that all countries give due consideration to the model law in view of the desirability of the uniformity of the law. Again, they want every domestic municipal jurisdiction to have the same law. Which law? Which is the 1985 model law of the law of arbitral procedures and the specific needs of international commercial practice. The split millers is you generally adopt this where there is some variation. Therefore, we have part 2 of our act. The Conceptual also adopted in 1980 a set of conciliation rules. The General Assembly of the United Nations has recommended the use of these rules in cases where parties arise in context of international commercial relations, parties seek amicable settlement by recourse to conciliation. And important of the Conceptual model law is they have harmonized concepts of arbitration and conciliation of different legal systems of the world and thus contain provisions which are designed for universal application. All across the world, setting aside means setting aside. When it doesn't mean, provide for a difference. If we want harmonization, we can't in India say
that harmonization is something different. What they're saying is apply the same law, but the fact of the matter is several countries, including the Western world, where arbitration is perhaps the default mode in commercial arbitration, commercial matters, they have power of modification.
That is statute.
You can't argue that if you bring in modification, you'll be violating the international.
No, that's not what I'm saying. What I'm saying is a particular Allow me to read this line again as to what I'm trying to say. What I'm trying to say is that the Conceptual Act and our act was.
You may be right to that extent. You may be right to that extent. But during the course when the discussions was going on, whether model international law of international. At that time, they said modification should not be, there was debate whether modification should be included or not, and they left it. They left it at that.
Yes. Look, what I'm trying to say is, what does the word setting?
It is clear that
Yes.
they did not want to lift it as it is for the domestic arbitration.
I'll read paragraph 3. Let's read this. But while reading paragraph 3, we can't forget the last line of paragraph 2, that the intention is to actually adopt that 85 model law
As a model law,
as a model law.
with certain modifications necessary to
Certainly. But Millers,
suit the domestic needs.
unfortunately or fortunately, none of those modifications happened. It was open to the legislature of India when adopting that 1985 model law to make suitable amendments. Where they made suitable amendments, we know. Where they've not made, they've not made. And where they're not made those amendments, we can't then say that even though you chose not to make those amendments, we will somehow read a power that there was an intent to depart from what was commonly understood. What was commonly understood in 85 and 96, setting aside means only setting aside. The legislature chooses not to depart from that. It was open to it. They chose not to depart from it. Having chosen not to depart from it, we can't say that even though they chose not to depart from it, merely because they could have means that they have. That does not follow, Millers. It was open to them to do that. And in fact, I would argue the reverse. Even though they could have, but they didn't, means that setting aside means only setting aside. Because we are sitting here in an interpretive exercise. We are not sitting here as legislators or in some kind of constituent power. If the intention is to be determined of Parliament, the intention of Parliament is very clear, whether we like it or not. The intention of Parliament is clear that what does the word setting aside mean? Setting aside, Millers, it's Lord Atkins, famous Liversidge and Anderson. Words mean what they mean. Setting aside, we all means annulment, which is why we are now struggling to find modification, variation elsewhere, which is why CPC always says modification is different from variation. The Arbitration Act says modification is different from setting aside. This concept of setting aside is conceptually different. There is no way of reading into the idea of setting aside and a concept of modification. I'll come to the second argument, which is that it is a lesser or a greater power. But I'm on a point A here, which says that you cannot interpret the word setting aside in any manner other than its natural meaning and the meaning as described in Redfern and Hunter, and as understood by every country across the world, as understood by India in 1985 and in 1996. Suddenly, Millers, in 2025, they can't suddenly be waking up and saying, no, actually, that's not what they meant. What setting aside meant was modification. Well, this stroke of genius that we lawyers sometimes get to read words interestingly and differently, this cannot work when the words of the statute are clear. They're as clear as daylight. We may not want it, I repeat, we may not want it, you may not like it, but there has to be some judicial discipline, Millers, also, with the greatest respect. Because, Millers, I repeat, nothing is a greater anathema to the world of commerce as unpredictability. This constant flip-flop, change, etc., Millers, is actually a greater danger. Two parties have decided that we can go to court.
I don't think that argument, the last argument was, because the commercial world also wants certainty in litigation.
Yes, Millers.
And not continuity of litigation.
Millers,
That's the argument of the other side is, why do you expect courts will not be able to be appropriately apply the law, even if it is modification, in cases where there is need and strictly within the four corners of law, without going into the merits of the matter, without going into the rewriting the award. In those limited set of, they are not asking that it can be court can sit in a judgment in an appeal. And as was suggested in some of the cases, in one or two cases, there is suggestion, but most of the advocates on the other side have never said that we should become the appellate one. Nobody said that, except probably in public policy matters relating to NHAI.
Well, the question is not as to what is desirable.
Nobody's argued.
It is a question, Millers, of what is the law. That's what I am on.
Let me put it very clearly. As far as commerce is concerned, that may not be. The first argument of yours,
No, Millers,
that if we have adopted the unilateral model
yes.
and the intent of the legislature was to exactly take up the unilateral model, then setting aside doesn't include modification. To some extent, maybe right.
So look, again, just as a legal framework, is just put it back, skeleton of legal framework. You can't add words to a statute. You can give. I'm just finishing my point. Second is you can read modification into setting aside if the words itself have some ambiguity and permit for that. I'm argued that is not the case. That is not possible. There is no ambiguity in the meaning of the word setting aside. Through no process of interpretation can we read variation into the setting aside. That's the second point. Third point, Millers, is whether the greater includes a lesser. In another way, Millers, I suppose, of saying that the word setting aside may include variation or modification, even if the golden rule of interpretation, which is read the words as they are, is not to be taken, and that was also argued by the other side, is through some form of purposive interpretation, that you interpret the words of a statute so as to effectuate the policy behind it. That has been, Millers, a substratum of a large part of the argument of the other side. But I'll say some things to that. One, that principle can only be adopted when there is an ambiguity in the words of a statute. It cannot be adopted generally. Where is the ambiguity in the word setting aside? It's as clear as daylight. It's clear, Millers, to us in 85, in 96, to this court, Millers, in Hakeem, to Redfern and Hunter, to every country across the world, which was given a separate power for modification. So they know what setting aside means. It is clear to our legislature in 1908 in the CPC when they say there's a different power. To all authorities so far, these two powers have been seen as distinct, and setting aside means setting aside. Well, it's English language. So, well, therefore, there is no scope of a purposive interpretation. Then, well, if my note is to be seen, and assuming a purposive interpretation is to be adopted, then two things need to happen. First, you determine what is the policy of the act. And second is to ask yourself as to whether the interpretation being sought to be offered will further that policy of the act. Both things, Millers, in purposive interpretation, my laws will do these two tests. What is the policy of the act? Very often it has been said that, look, it becomes very expensive, very expensive. No part of the arbitration exercise is to make it cheaper for parties. It is well known that arbitration is more expensive. What is important and has always been stated in every judgment of this court, including the Stamp Act judgment, if need be, I'll refer to it, is the policy of the Arbitration Act is twofold. One is minimum judicial interference, embodied in section 5. And the second is expedition. Expedition and non-interference. And Millers, I would dare say that non-interference is a concept which is in furtherance of expedition. Well, if non-interference is the purpose of the act and expedition is the purpose of the act, one, I would say, leave the expense of the parties away. Parties know when they choose that they're going to arbitration, that they may come with a situation where the award is set aside and they'll have to restart it. They do that in commerce. It is not a problem. It is parties well know that. Yet they choose to opt out of a general judicial system and go to arbitration. So if expense, please leave out of it. The consideration of expense, parties are presumably factored into their own mind when signing that contract, because it is party autonomy. Parties know what they're doing. So the question is, Millers, of expedition. Well, if legislature says section 5 in furtherance of expedition, I dare say the question will then come to the second part of the purpose of interpretation test is whether modification and the power of modification will expedite the process or further retard it. By reference to 3 examples coming from other side, think, look in my case, modification would have quelled the litigation there and then, forgets the fact that it would, I repeat, in this court it may quell it because there is no further ground of appeal. If that power is to be exercised by every single trial court, even the high courts will exercise a trial jurisdiction when they have original side. But it is also exercised by district courts in every country. In every court in this country, there will be an application of a modification, no matter what guardrails my lord gives of curable, incurable, this, that. Every party will say, well, look, this is a curable defect, cure it. You can do it. The other party will say either you should not have cured it, it is inappropriate, or it is not a curable defect. There will be one round of litigation which will go on that alone. Because I give again the salutary example of
That may not be correct for the simple reason the power to modify will only arise in case the first the court forms a conclusion that the award is patently wrong or contrary to public policy and therefore it's liable to be set aside. First, you have to form that conclusion. You cannot, without forming that conclusion, modify the award.
Yes, but then my lords will then, if they give my lord gives a restriction saying having come to this conclusion of patent and
Yes,
legality.
therefore, the expedition part is therefore built into their argument that first we have to form that way. So they argued that way. They said, please do not read the award that we are asking to take the power of the appellate court. Don't read it like that. Except some of the counsels did argue in public policy matter, the approach of the court in 34 should be much broader and wider.
Because I ask myself, if
And
conceptual,
to be fair to them, they also argued about 300A. So that was also
I'm not such a jurisprudent as to
they argued about 300A,
Yes.
saying that a property is being taken away. What is being given, what is the adjudication, the arbitration is by a government officer. And therefore, if you're not going to read 34 broadly, to include the power of modification, it may lead to difficulty. So Arbitration Act, as enacted by the Parliament, is not only being applied to pure commercial matters, it's a list of 9 acts where Arbitration Act or the provisions of Section 34 have been made applicable in statutory arbitrations also.
there's one very simple answer to that. You are now using a different problem to solve a different remedy to solve a different problem. If the argument of 300A is that you need recourse to a wider power of re-examination, then Millers, this restriction of 34 of patent illegality and public policy is wrong. It's not modification. It's not what court can do with it. You would then need to challenge the substantive act and say that my recourse to court is limited by these principles of public policy and patent illegality, these narrow forms. That is under challenge, Millard, not what the court can do having found so this argument has really no merit. Then you please challenge those individual acts and say that why are you following arbitration with its restricted appeals? Please follow a regular procedure. You file a writ petition if need be, you go to court, you challenge that act, whatever. This will not solve anything. Reading the power of modification will not solve the problem of 300A as long as the rest of Section 34 stays. Because then that is the ground, because if that argument is to be adopted, then please blow a hole in what public policy and patent illegality means. My lord was saying that we read that it's only when the court comes to the conclusion of patent illegality and public policy, because what was public policy was understood in a particular way, then comes ONGC, understands it in a different way. Because that set off from 2003 to 2025, a certain shell shock, the effects of which are still being felt. No matter how precisely my lords lay down the contours of any alleged exercise of power, because every party and their clever counsel will examine the boundaries of that. My lords will first determine whether it's policy or not. Secondly, Millard, if it's restricted but curable, there will be, again, every party will test as to what is curable or not. My lords have laid down principle upon principle in section 115 of the CPC, article 227, in the rare article, dare I say, article 136 of this constitution. Very restricted, only on these instances. How often are those principles followed, Millers? And the way there has been a boom of revisions and 227s, every 34 court would become like a revisional and appellate court. And rather than Millard being expedited, it will retard and completely act contrary to the purpose behind the statute, which is speed. Where do we get this, Millard? This argument can't be taken at face value that because the court has the power to modify. My lords are not sitting in the final court. I repeat, my lords will just see the trial court, what the trial court will do. That trial court will modify, Millard, if it comes, even though when it is not required to be done, as a revisional court often indulges. And then, Millard, again, I repeat, that round of litigation starts, delaying arbitration. And here, Millard, again, I ask myself, in the last 30 years, save a few instances of individual injustices where, at best, the party is not remediless. The party can start an arbitration again. It may be expensive, but not being expensive is not a part of the problem of arbitration law, why it exists.
But what happens if the clerical error application under 33,
Yes, Millard.
a patent clerical or arithmetical error is not considered, it is dismissed by the arbitrator?
Millard, there the legislature has given a power to the court to step in and do something about it.
Where is that? 33.
33 Millard. One is 33.3. Within 30 days, either you go to the court, go back to the arbitrator.
Yes.
If the arbitrator doesn't do it, then 34.4.
No,
But if this power exists, you go back. The question is, why should the court have this power?
I'm on clerical and
Yeah.
arithmetical error.
Yes, Millard. Even under
Even
34.4,
that without 34.4 you can't do.
Millard,
All right.
it
Now-
is
now,
not as a party is remediless. The question is, where is the remedy?
No.
Is that remedy before the court or before the arbitrator?
All right, then time limit for challenging the award expires. It attains the status of a decree. Will 152 CPC be available at that stage or not? Because
Right.
152 is available only when it becomes a decree.
Millard, no, I would say no, because it doesn't become a decree. Under our act, unlike when it made a rule of the court, our award does not become a decree.
No, it is enforceable as a decree.
Enforceable as a decree is different than being a decree.
It is a
Because Millard,
fiction.
if
It is
there
a
is a
fiction.
big difference between being enforceable as a decree and it being a decree. There are several judgments, if my lord wishes, we can cite them. It has always been understood that this is not a decree, because Millard, if it becomes a decree, then that problem, Mr. Pushkarna, comes into play. If it's a decree, then why is it not challengeable under section 96? It's not. It is not a decree, Millard. It is enforceable as a decree means an Amazon that has been held. It is not the law of our land that an arbitral award becomes a decree. It is very clear it is not.
As if it were a decree.
As if it were a decree. I mean, it's a deeming fiction for the purpose of an execution.
Even 152 can't be exercised.
May not be, Millard. Because these are timelines specifically.
So a 34 court without 34.4 cannot even correct an arithmetical or a clerical.
Millard, it may seem shocking.
It is shocking because
Maybe.
152 power
Yes, Millard.
is founded on actus curiae principle.
Millard, actus curiae would be the tribunal. You go back to that tribunal which is acted in that way will correct it. It is, I repeat, not a case where the party is left remediless.
Doesn't correct it.
It is not a case of ibi jus ibi remedium. That is, I suppose, the principle, and my lord Justice Vishwanathan is mentioning. There is very much a use, then there is very much a remedium, only the forum changes. The forum is not, well, this is a way to read this act which is logical. Now we're trying to find a better way, is not the way which is permissible.
Sorry.
I'll leave it at that. I think and the power of greater and lesser I've already pointed out.
Or,
I have lots more, but I will follow the discipline. My laws has indicated they don't want to hear. I will not. I will say nothing.
Mr. Gaurav,
Mr. Banerjee will argue.
Gyanesh. How many of you are there from this side?
That's it. May it please. My lord, there is something inherently appealing in the argument of the petitioner. Justice has been done. That's the first, my lord, point that certainly strikes a judge, that some injustice has been done and we must step in and solve the problem. This is, my lord, the first. There are three limbs to the argument. This is the first, my lord. Prima facie looks very appealing that some injustice is being done to me. Why should not the court after?
I will not go to that extent. Let me put it very clearly. Normally, as a court, there are two factors which play with us. One is to do justice, remedy the wrong. That's a factor.
That's the instinct, my lord. That should and is
No,
should be
but
the instinct.
If there is something wrong, let's
not fix the
remedy
problem.
wrong. Two is the courts like to normally assume a power because adjudicatory functions should not be curtailed.
So, my lord,
Not be unnecessarily curtailed until unless the statute specifically, expressly, or by
so,
implication takes away that power.
so if I can summarize, not the other side, there are three limbs to the argument. One is, if there is some injustice, court's power should not be curtailed. The court ought to, as a matter of justice, step in and fix the problem. This is proposition one, my lord, which itself I will say something on. Proposition two is, if that be the case, then maybe 34 does not have the word vary or modification. However, in order to, my lord, support proposition one, I will persuade the bench to read it in one of three ways. One is adding words, one possible submission. Second is read it in 34(1) as part of setting aside. Second possible interpretation, according to me, my lord, the one which we will have to deal with. And third, forget 34(1), let us read it in 151. So this is point two, my lord. So point one is the court should have the power. Point two is, if the court has the power, these are one of three methods to do it. And three, realizing there's a problem with an untrammeled power, we realize there's a problem that there cannot be untrammeled variation. Guidelines have been suggested by various parties in various different ways. Possibly all of them, my lord, suiting their particular facts of the case. So everybody has their own, my lord, guideline, which perhaps will fit whatever factual background that particular individual has to place or perceived injustice. Lord, we are in a position, my lord, as the learned solicitor, my lord, we are not here on any particular set of facts. There are weighty arguments.
They are appearing for whom?
My lord, I am appearing for UNCITRAL, UNCCI, my lord. We have intervened as UNCITRAL. There are weighty arguments, my lord, which have been made on the other side, no doubt, my lord. But I will just, my lord, I think we should step back a little, because I think, my lord, we are proceeding on a bit of a misconception, which is this. My lord, we are treating this as an appeal from a judgment. In our mind, my lord, in the court's mind, that the thinking is that this is in some way an appeal from a decision by a inferior court. And my lord, there are at least, I'll attend them, my lord. My lord, there are at least 3 or 4 aspects which your lordships will consider before coming to the next question is, when can you attack an award? So, my lord, what is critical here is that an award is a baby of a private dispute. It is supposed to be out of the system. It is not supposed to be in the system. It is supposed to be out of the system. There are some implications here. My lord, an award is meant to be final and binding. Very important. It has to be final and binding. It is a consensual process. The moment the arbitrator finishes, his mandate gets over. Consent is over. Subject to, of course, correction and remand. The mandate is over under Article 32. The arbitral tribunal becomes functus officio. So, my lord, there are two policy aspects to an award which are not there in a lower court judgment. One is party autonomy, and I'll explain what is the relevance because I think this is crucial. And secondly, my lord, finality. You go into arbitration, nobody is forcing you, my lord. We have to proceed on the basis that nobody is forcing you to go to arbitration. It is a consensual process. The consequence of this, which has not been, my lord, probably appreciated by the other side, is an arbitrator can be wrong. An arbitrator can be wrong on the merits. He can be wrong on his appreciation of evidence. He can be wrong on the interpretation of law. But the law provides that because I have gone to somebody else other than the courts will never tolerate a wrong order. But I have gone to somebody else, I will take that wrong decision because I want finality. I want a binding award. Therefore, my lord, 34 is restricted that it has to be at the level where there has to be patent illegality. So, my lord, the first point I want to make is, please do not consider this as an simply, my lord, the intention is to keep it out of the courts. So, my lord, however much the instinct is to render justice, that justice has not to be rendered by the court, but that justice has to be rendered by the tribunal. Where your lordships are eager to fix the problem, the first proposition, the law provides and the statute provides that that is a remedy available to the tribunal. And opportunities are given to the tribunal in every stage. A lot award comes if there is clerical, etc., mistake. Then under the old act, section 15, which your lordship was referring to, it went to the court. But that is no longer the case. Section 33 is qua the tribunal. Please keep tribunal on one side, court on one side. 34(4), again an option. Surely the court could have intervened and said, I'm fixing the problem. No, the intention of the law is save the award, go back to the tribunal under 34(4). No, I'm not on the scope of 34(4). Go back to it. No, the third option. Why is setting aside so critical? Not because of essentially, why is modification not provided? Because of the problem of cherry picking. If you actually believe, if you really believe that that tribunal has messed it up, that it has not followed natural justice, or it has gone completely outside the jurisdiction, or it has made such an obvious patent blunder, why should you trust the tribunal's judgment on other points? I'll give a simple example, and it happens every day. 5 claims are made. 4 are rejected. 4 may be wrongly rejected because it may have been in appeal reversed, but 4 are wrongly rejected. There is no 34. The 5th claim is allowed, but even there the arbitrator commits a mistake, maybe on the overhead or A, B, C, D. If the court tweaks, let us say 5, what is the consequences? You are cherry picking one part of the award. The person who has actually lost, in a sense, because 4 of his 5 have been wrongly disallowed, has no remedy because he accepts the wrong judgment of the arbitrator. So, my lord, when your lordships come to a conclusion of pay, it's a very serious matter to set aside number. When your lordships come to the stage of patent illegality or the stage of setting aside cannot be the norm. Then, because of the seriousness of the matter, the set aside follows because your lordships have lost faith in the tribunal. It is not an appeal where your lordships will modify this, change this. So, this is my first.
if he has not challenged the rejection of the 4 claims,
My lord, he may have not been able to challenge the rejection of the 4 claims because even though it is wrong,
why?
because he can't.
Several degree, if he several claims.
No, I'm saying, my lord, it is, let us say it is connected. He cannot challenge those 4 wrong decisions because, my lord, unlike in a court, arbitration is not right or wrong. It may be a wrong decision on appreciation of evidence. It may be a wrong decision on appreciation of law. But because of the discipline of arbitration, you have accepted Mr. So-and-so as your arbitrator. You can't challenge under 34. That's the whole point. Otherwise, my lord, you have, that's why, my lord, the moment we bring.
Yeah, Mr. Banerjee, let's be very clear. There is a viewpoint, and in some countries that arbitration is a compromise adjudication, which has its own weight and disclaimer, but in the United States, there's a big move on that. Twice they have tried to introduce legislations
My
to
lord,
curtail arbitration. There are issues,
I can go
but we are not going into that question.
much further.
We are not going into that question. We leave it at that.
My lord,
We leave it at that. But the fact of the matter is, where we are not saying interfere and modify. We are saying first you have to come to the conclusion that the award has to be set aside. If you come to the conclusion that the award has to be set aside, then in case the defects are curable, either in terms when a court can interfere and cure them, or then go under 34(4). In fact, what you are arguing is contrary to 34(4).
my lord, I'll just come.
Because once you're saying that once you've lost, that the arbitral tribunal has not done something wrong or has done something wrong, sending it back again under 34(4)
I'll
will
just,
serve no purpose.
No,
You're yourself arguing that.
let me, my lord, come to
You're yourself argued to that extent.
my lord, my first proposition is this.
So we are neither tinkering with the clauses on which the award can be, the argument of the other side is do not tinker with the clauses under which the award can be set aside. Yes, if you come to the conclusion that the award can be set aside, then you have 2 options, 34(4), or if it is a curable defect by the court itself, because then you do it.
May I just, my lord, respond to that?
So you please confine yourself to that part.
My lord, I'm responding in legal and practical terms. There are 5 separate concepts here as to how an award can be attacked. My lord, I'll hand over my note. No? One is the power to confirm an award. Under our law, under the 1940 Act, there was a power to make an award rule of the court. Under some statutes, there is power to confirm an award. Model law, and we do not have there is no role of the court in confirming an award. The role is a negative role. The role of positively affirming, confirming an award does not exist either in the model law or in the 1996 Act.
Except part 2, the recognition part, maybe a.
Recognition is also, my lord, not confirming an award. Recognition is a completely separate concept. My lord, the second concept is of variation. I am not using the word modification, my lord, because modification can mean many things to many people. So, my lord, the word which is used is variation internationally. Variation means that you affect in some way the relief, or you modify and enter and cross the Lakshman Rekha into the merit. So, my lord, there is variation. That is one second concept. My lord, the third concept which your lordship has is correcting an award. Correcting an award, which was earlier there, my lord, in section 16 of the Act, is now placed in Article 33, which is our section 33, which in fact is important because it gives power to the tribunal, which was earlier there before the court. Now, my lord, all these concepts are relatively clear. Now we come, my lord, to the fourth concept of remission. Remission also has a particular meaning. Lord, remission is when the court sends the matter back to the tribunal. That's all that remission means. 34.4 is where you send the award back to the trial. I'll hand over my note. We have quoted some portions of the ancestral model law. Remission is remand to under Article 34.4. Now, my lord, very interestingly regarding remission, unlike the previous law, there's commentary on this, remission was a standalone power of the court. You can remit. Here, advisedly, and the learned solicitor has read it out, remission is couched specifically within the set-aside provision. 34.4 is placed, well, Lord, remission could have been a separate power like in the UK, etc., where you simply send it back with some directions or otherwise, etc., and then the court, whatever happens, there are statutory provisions. Remission means within section 34.4, I am not going into the scope of remission because there are at least 3 judgments of your court, of your lordship's court, which have explained remission. There is also a court of appeal judgment of the Singapore court, which has also explained remission. So, my lord, I am not going into remission. Your lordships have settled the law on Article 34.4. Subject to what is being said, my lord, there are the IP is the latest judgment. It is there. The idea again, my lord, one has to look at this. Idea again is the legislature intends that it is the tribunal in which you have faith, which is given the power to cure the defect. The legislature did not intend that this power of remission is to be exercised by the court itself in the first instance. It did not, my lord. It said that if you find it appropriate, you, on an application of a party, again, my lord, not suo motu, on an application of a party, adjourn the matter. First send it back, then adjourn the matter. That's the language. So that if the curable defect is cured, your set-aside ends. You don't need to bother with a set-aside if the defect is cured when it comes back to you. Again, my lord, that's the logic. Now, my lord, we come to the most important aspect of annulment and set-aside, and whether annulment and set-aside encompasses within it the concept of variation. You know, I'm very careful to use the word variation because modification, again, we don't know where it stands. Does the concept of setting aside encompass the question of variation? My lord, there are some passages. I'll just read first, if your lordships permit me. Before I come to this aspect, I will read 2 paragraphs from Redfern and Hunter, my lord, which is applicable across the board. It is a very, very pithy paragraph, which perhaps your lordships will understand where I'm coming from. Please see page 150 of volume 4. It's a very interesting paragraph. I think it says a lot. Yeah, we can hand over. Well, we can hand over this. I'll just hand over the submissions. Okay. Yeah. Here, well, it starts with the sentence. It's the chapter headed "Challenge of Arbitral Awards." I wonder if your lordships have got it. It starts with the sentence, "No one likes losing." So it is not surprising that when a client is disappointed with an arbitral award, the first question the lawyer is asked, how can I appeal? As is so often the case when a lawyer is asked a question, the answer is, it depends. First, it depends on whether the relevant rules of arbitration establish any internal appeal procedure, as is the case in certain maritime and commodity arbitration systems. You know, this is like central trade, etc. There is an internal appellate procedure. It is noteworthy that most arbitration rules do not provide for such an appeal. Indeed, most institutional rules provide unequivocally that an arbitral award is final and binding. Well, this is our section 35. These are not intended to be empty words. One of the advantages of arbitration is that it is intended to result in the final determination of the disputes between the parties. If the parties want a compromise solution to be proposed, they should opt for mediation. If they are prepared to fight the case to the highest court in the land, they should opt for litigation. By choosing arbitration, the parties choose in principle finality. An arbitral award is not intended, and I rely on this a lot, not intended to be a mere proposal as to how dispute might be resolved, nor is it intended to be the first step on a ladder of appeal through national courts. This is something your lordships will keep in mind while considering whether the power of modification should be exercised by the court. So, my lord, one aspect of this is, one policy aspect of arbitration is finality. And I'll show, my lord, that is what our 5-judge bench in Raipur, Chokamal has also said. Finality is one major aspect. Similar to the losing at disadvantage may seem retrospect very opposite. Laws of many countries reflect the policy of New York Convention. What has been described pro-enforcement bias means that while it may be possible to challenge an arbitral award, available options are likely to be limited and intentionally so. I'm not reading 10.04 and 10.05 for the moment. Please come to 10.06. The purpose of challenging an award before a national court at the seat of arbitration is to have that court declare all or part of the award null and void. If an award is set aside or annulled by the relevant...
Just 1 minute. Whole or part of the award.
Yes, part of the award can be null and void. Can be partial set aside, my lord, is well recognized. There's no dispute. That is, my lord, my learned friend will address your lordship. Partial set aside is effectively, my lord, partial and no difference. Not only by the courts of the seat, but also by national court. This is because under such New York Convention model law, competent court may refuse to grant recognition and enforcement of an award, which has been set aside by court of the seat of arbitration. Important to note that following complete annulment, the claimant can commence proceedings because the award simply does not exist. That is, status quo ante is restored. This was mentioned, my lord, in the Hakim judgment. The reviewing court cannot alter the terms of an award, nor can it decide the dispute based on its own vision of the merits. Lordships will consider whether, by granting to your lordships the power of modification, is the court going down this path? Unless the reviewing court has the power to remit the fault to the original tribunal, as in England, a new submission of the dispute to arbitration after annulment has to be undertaken by commencement of new arbitration. So, my lord, this is 10.6, which has been set out in Hakim. But what is more important, my lord, is 10.1 and 10.2, which is the aspect of finality, which is a crucial policy aspect which your lordships will consider. Now, my lord, I want to show one judgment on what annulment means, because it's very important, my lord, to understand what annulment means. We have all been talking about the words, my lord, internationally used are set aside, annulment, vacatur. What does this mean? And, my lord, we have there are, of course, my lord, Singapore judgments. I will meet the point specifically lays that Singapore law has a prohibition. I will show, my lord, that is probably not a correct interpretation. I'll show that. But I want to show your lordships first the Topfer judgment. Page 185. 3 very interesting paragraphs.
Page
185. The other side had cited modern laminators, learned single judge Justice Endlaw. Obviously, my lord, with the passage of time in the division bench, he perhaps revised maybe he was wiser, is all I can say. But this is my lord, there are 3 paragraphs here which have some resonance. Please see paragraph, please note the paragraph 7, 8, 9, 11, and 14. I will only read 7, 8, and 9. Annulment is intended to be a faster and less, arbitration is intended to be a faster and less expensive alternative to the courts. If this is one motivation expectation, then the finality of the arbitration award is very important. The remedy provided in 34 against an arbitral award is in no sense an appeal. The legislative intent in 34 was to make the result of the annulment procedure prescribed therein potentially different from that of an appeal. In appeal, the decision under review not only may be confirmed, but may also be modified. In annulment, on the other hand, the decision under review may either be invalidated in whole or in part, or be left to stand if the plea for annulment is rejected. Annulment operates to negate a decision in whole or in part, thereby depriving the portion negated of legal force and returning the parties as to that portion.
The unilateral model uses term annulment or setting aside.
My lord, I put it in my, the ancestral model in English uses setting aside, in French,
No, in the, as originally drafted.
setting aside, and in the French, which is the model law, uses annulment. Both are used interchangeably. I put the French law also. This is the same. Some
No, but the unilateral, there's a French
official version,
official version of unilateral which uses term annulment.
annulment.
But annulment in French may mean something different from.
It means the same. Lord, I have French judgments also, but I'm not going to. But the word which is used is annulment.
No, but the French phrase annulment or the word for annulment
Is identical.
may, look,
I will.
like if I have to find a Hindi word,
Sorry.
if I have to find a Hindi word for setting aside, it may be wider, it may be narrower.
My lord, the general understanding of setting aside or annulment or vacation, the other word which is used internationally is vacator. You vacate the award. You obliterate the award. You quash the award. My lord, may I just, in annulment, on the other hand, the decision and the review may be either invalidated in whole or in part, or be left to stand at the plea for annulment.
What was the issue over here?
My lord, 34 interference in appeal. May I just,
But they were not going to the question of.
modification, yes, modification was also argued. Well, please just see these 3 paragraphs in order to understand, well, what is this concept? In whole or in part, thereby depriving the portion negated of legal force and returning the parties as to that portion to their original litigating position. Annulment can void when appeal can modify. Section 34 is found to provide for annulment only on the grounds affecting legitimacy of the process of decision as distinct from the substantive correctness of the contents of the decision. A remedy of appeal focuses both on the legitimacy of the process and the substantive correctness. Annulment in the case of arbitration, not on the correctness of the decision, rather more narrowly considers whether, regardless of errors in application of law or determination of fact, the decision resulted from a legitimate process. In the case of arbitration, the parties to the agreement create an entirely different situation. Regardless of how complex, simple dispute resolution mechanism they almost always agree that the resultant award will be final and binding on them. In other words, regardless of whether there are errors of application or ascertainment fact, parties agree that the award will be regarded as substantively correct. Yet, though the content of the award is thus final, parties may still challenge the legitimacy of the decision-making process leading to the award. In essence, parties are always free to argue, not bound by a given award, because what was labeled an award is the result of an illegitimate process. This is the core of the notion of annulment. In a sense, annulment is all that doctrinally survives the parties' agreement.
Then patent illegality being introduced in India.
My lord, patent
One-
illegality.
One, Mr. Banerjee. Once patent illegality being introduced in India, will it not, will the unilateral model still be completely applicable?
Patent illegality has now been introduced. It was first spelled out by the court as an aspect
So
of
will it
public.
not impact the whole,
I will come
model
to
to
that
extent as well as domestic.
separately on 34(2)(a) as to, my lord, one argument that
No, I'm not on that. That's a separate argument. Complete reliance, therefore, on unilateral model may not be appropriate once the Indian legislature has brought in the concept of patent illegality.
my lord, for patent, this is what was argued by Mr. Kambata, that modification should be restricted to cases of patent illegality. There is a reason he argued that, and my lord, there is a consequence if modification is to be read into the other provisions. There is some, my lord, I'll come to that. But my lord, even a case of patent illegality is not a correction of merits. It's not a correction of merits.
We are not saying that.
And
Neither has anybody argued that. except
when you
in
have
case of
patent
an AGM.
illegality, it is so extreme a situation that the legitimacy of the process and the fact that it is a legitimate award does not pass your lordship's muster. If you are saying somebody has done something not illegal, but patently illegal, then how can you have faith in that arbitral tribunal? How can you then tinker with it? Then that man has to go. If you genuinely believe that he's done something wrong, which is so illegal that it shocks the conscience and it is at the root of the matter, then he should go. Where's the question then of, my lord, saying, all right, this is okay, that's not okay. No, that's what I'm on. Please see para 11. Just half that paragraph, no, I'll leave it. 14, your lordships will see as to the what is being said. No, this was arbitration in 1940 Act could not achieve the savings in time or money for which it was enacted, merely became a first step in lengthy litigation. Reference in this regard can be made to paragraph 35 Balfour. It was to get over that said malady, a law was sought to be overhauled. While under the old Act, award was unenforceable till made rule of the court, for which it had passed various tests laid down therein. General power authority was vested in the court to modify it. All this was removed in the new Act. New Act not only made the award executable as decree after the time of preferring objection, respect thereto had expired, without requiring to necessarily be made law, but also did away with the condemnation of delay in filing objection. Reason, purpose being expediency. The grounds on which objections could be filed are also such, if it made out, this I would respectfully submit would also apply to patent AL. The only consequence thereof would be setting aside the award. It is for this reason that under the new Act, there is no power to the court to modify the award or to remit the award, etc., subject to 34 under the old Act. So, then I continue. I will not continue reading. The lordship may just note para 14. So, the second limb of my subject. First limb was that we are not looking at a judgment. We are looking at an award. An award has some particular features. The second limb of my argument was that there are conceptually 4 or 5 aspects. Annulment is different. Modification, variation is different. Correction is different. Remission is different. Confirmation is different. All are different. They are all well understood concepts. So, my lord, whether annulment, whether variation of award can be fitted in to the set aside. That's, my lord, my the third proposition, which is I'm not even answering, my lord, question the 3 points. The first is adding words, my lord, that has already been addressed. The third point, which is quite alarming, my lord, is the bringing in of 151. There are some significant consequences. If you bring in 151, you automatically bring in 115, you automatically bring in Order 41, Rule 22. That reference.
No, that's not been argued. What has been said, 151 is not really that way. What has been said is, once you give a power, even on 34, there will be some ancillary and residual powers which flow with every forum. And that's the objective of any procedural section. No procedural enactment can visualize and deal with all sorts of situations.
So,
that's why, except in Evidence Act, we always say everything is permitted until unless it's expressly barred or impliedly barred. You don't have to look at the provisions of the CPC or the CRPC to find out whether a particular procedure is permitted or particular way.
And come to the 7 judges on that. Our Act flips it on the head. Our Act, and particularly the way it has been understood, also where lordships were there in the 7 judges, that our Act says, and the 7 judges do say, that Arbitration Act is a complete code.
No, that's
that
fine.
portion has not been written.
Irrespective of the fact that CPC is a complete code, these are the principles which are applicable to procedural laws.
I will go.
We are dealing with both 2 aspects, procedural law as well as substantive law in arbitration.
My lord, may I just put it in this way? One argument could be you read into section 36, the word phrase set aside, you read into the word vary. This is one separate argument.
And it also says this. It also says this CPC and Evidence Act are not applicable to arbitration.
My lord, in fact, very interestingly, under the old Act, the other side relied on ITI. ITI has been doubted in MTNL. And the reason for that doubt is,
That we have understood that because there was a appellate remedy then provided.
and my lord, there was a specific provision under the old act, your lordships will note this. There was a specific provision in the old act incorporating the CPC. Specifically, that which is not there. There were, I think, 41, 40, section 41, specifically bringing in CPC. So, my lord, we have to get out of that, should I say, my lord, CPC mindset for a moment. So, my lord, the question which is put is that why should annulment not include variation? This is the argument. This is the highest that it can be put. Why should it not include? My lord, one, I have already argued, basis, you know, this Topfer judgment, and there are a couple of Singapore judgments which I will show, that these are two different concepts. Variation is certainly possible if you have the power to confirm, or in an appeal. Then of course you have the power to vary. But in an annulment, it is a negative power. The difference between annulment and Lord, variation is where the Lakshman Rekha has to do. You know, annulment is a negative power. What the court does is, and the language is simple, you don't like the award does not pass muster. You set it aside, you stop. Why? Because the next step is always with the initial forum which you contracted to. The moment you cross the Lakshman Rekha, then you are wearing a different hat. You are wearing the hat of virtually appeal. Because then your substitute, that is the sentence which I read in Redfern and Hunter, you are substituting, you, my lords, will be substituting your own vision of the merits into the award. So, my lord, there is a fundamental distinction between annulment and my lord, it is extremely difficult for somebody who wants to do justice to hold back. And sometimes, my lord, it is necessary to hold back in order to do overall justice. And I will make it good. Now, my lord, one argument which was put is squarely by the other side. I have had the benefit, my lord, now your lordships have transcript. So I went and read the transcript as to exactly what was argued. My lord, what is argued is, why look at the Singapore law? They have a prohibition. We don't have a prohibition. The law there is different. The law here is different. That was argued by Mr. Kambata and also Mr. Rai. And my lord, the section that was pointed out was section 47 of the Domestic Act. So, my lord, here is the problem. Our act, as my lords correctly put to me, considers both international commercial arbitration and what I would call purely domestic arbitration in part 1. My lords have 2(1)(f), both are there. 34 makes a slight distinction that 34(2)(a), which has been introduced, is limited only to domestic awards. We do not have two legislations. Singapore has two legislations. Well, not the first legislation that it has is the International Arbitration Act of 1994, which is the model law, which is the, by and large, the sections that we have in part 1. So, my lord, if we are to compare like to like, we will be comparing IAA 1994 with our part 1. The sections which are being relied on to say that there is a prohibition, 47 on the court. Well, not again, this problem comes court, tribunal, court, tribunal. The prohibition sections on the court are not in IAA 1994. It is in the Arbitration Act. It's all there in the note. In 2001, 47, 48, and 49 of the Domestic Act says you cannot vary except in such situations. So, my lord, it is not a prohibition in that sense. It is a almost, if you read all three, it's almost enabling. But that only applies to purely domestic arbitration where the legislature there has deviated from the model law. We have, my lord, in fact, we had recommended that there should be separate acts. It has not been done. We have only one act that has innumerable problems. But today we have one act, and today whatever interpretation your lordships give on section 34 will equally impact, this is very, very critical, will equally impact ICA situated in Delhi as also domestic arbitration. It will impact clearly. And it will have a very serious, impact across the board. So far as domestic awards are concerned, and those two judgments, AK and ALC, and the other judgment shown by the learned solicitor, I will show. Please.
Please try and conclude by 3 o'clock or 2:30, 3 o'clock, then we'll hear the results.
Please, I'll come to that. तो चलेंगे सर।
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।